Hello, everybody. Welcome to a very special episode of the TF Labs podcast. My name is Jonathan G. Blanco. I'm the guest and founder of TF Labs. Normally we do our podcast recorded and we play it back for you later. This time we're going live, and I'm really excited for my guest. His name is Paul Swegle. He's a lawyer, been an entrepreneurial general counsel for some great companies, done things with startups all the way to IPO, and even done things at the government level. And we're going to be talking about those things. He's just wrote a new book called Startup Law and Fundraising, and I'm excited to talk about that with him. So with that, please help me welcome Paul Swegle. How you doing, Paul?
Good. How you doing, Jonathan?
Good. Thanks so much for joining us. Do me a favor, and if you could introduce yourself to everybody, please.
Sure. I'm a native of Seattle. I have been general counsel for 13 companies. I've helped build and sell 4 startups to publicly traded companies. Most recently, I sold one called NewU to Abbott Laboratories back in May in the middle of the pandemic.
Wow.
Yes, I like helping companies build on a strong foundation, stay out of legal trouble, and raise the money they need to be successful.
That's great. Well, before we get started, again, everybody, thank you. If you're watching, please do us a favor. Let us know you're here, and just give us a quick shout. Where you from, or where are you listening in from? And we're going to try our best to get to your questions. So we might not answer them right as they come, but we'll do our best to answer as they go. So Paul, going back to just what you've been doing for the last, 20, or did you say 20 years? How many years you've been doing that?
Well, I graduated from law school in 1988, went straight to the Securities and Exchange Commission, and spent some years there, and then went straight into kind of business law.
Yeah. So, let's talk about the Securities and Exchange Commission for a little bit, right? So regulation and basically the ones that lay out the rules, right? What got you interested in starting there when you got out of high school, out of law school?
Well, I guess probably, I've always enjoyed business, and I've always known, essentially, I had a sister who was a stockbroker, and my family's always been in business. And I've always just sort of known, essentially, if you follow the money, you'll get to very interesting things. And the SEC sets the ground rules for how you raise money, and comes down on folks when they raise money improperly. So knowing the ground rules for successful and legal fundraising has been a kind of a cornerstone of my career. I've done $12 billion plus of deals. And so I think it turned out to be a good choice. I spent 5 years in enforcement and 3 years in the Division of Corporation Finance. So in CorpFin, I probably reviewed 140 IPOs. So very interesting work.
Wow. Yeah, I bet. And I bet that all becomes incredibly relative work when you're working with startups and, early stage companies, because there's so many rules, right? There's, and when you're in a startup, you're taught to, go as fast as you can, and kind of like ask for, don't ask for permission, but ask for forgiveness, right? But that can be troublesome later. So, kind of, how did you walk into the startup side? What made that interesting for you?
Well, after the SEC, I joined a very, I don't want to say stodgy, but kind of a stodgy company. I think it was a Fortune 50 company at the time, or certainly it was spun out of a Fortune 50 company. It was called Plum Creek Timber. It was the largest private landowner in the United States. It was listed on the New York Stock Exchange. And I had worked for Burlington Northern Inc. while I was a law student. So I spent 4 years there, and I had some, it was kind of a nice foundation working with senior lawyers and kind of, learning the ropes from some pros on the business side. And then in about 2000, when the .com thing was happening first, that started to look pretty exciting. And one day I threw my resume over the wall to a company called, at the time it was called NetStock. And I immediately got a call from the CEO who said, "Hey, I want to talk to you." And that company ended up being called ShareBuilder. And it was a very revolutionary online brokerage. And we built that thing from the ground up. It was the fastest growing online brokerage in the United States. We opened 1,000 brokerage accounts a day for years. And we ended up selling it twice. We sold it first to ING Direct, and then I stayed on and we sold it to Capital One. And so after that, it just seemed like I was kind of startup guy.
Yeah. Well, yeah. And ShareBuilder is definitely a great story. They're from the Northwest company, right?
Yeah, it came out of Bellevue actually, but we ended up anchoring in Pioneer Square in Seattle.
Yeah. And so, real quick, like walk us through some of the things that you might have learned in the beginning of that, right? So you're with them early, and then through IPO, or not IPO, sorry, but through the different sales and so forth. Like, what were some of the learning lessons from the beginning, and then how did that change as you matured? Is it different? Is it the same? Is it you maintain the same levels that you have to?
What I learned from ShareBuilder was that building on a strong foundation and doing things correctly from the ground up and avoiding lots of stupid mistakes is really smart. So ShareBuilder, when I got there, we're just raising a C round. So the company was pretty well established, and it had Wilson Sonsini as counsel, and just everything had been done correctly. We didn't have trademark issues. We didn't, we established good copywriting protection. We had a bit of a patent program, and we had very good governance. And we were very careful about not signing stupid contracts and making big business mistakes. And we were driving toward going public. And then in kind of 07, 08, the markets blew up. But that is the time frame in which we sold to ING Direct, which in hindsight, everyone said, oh, that was brilliant. You sold it at just the right time. I think really we sold because our VCs were getting a little long in the tooth. Their funds were getting old and they needed to get out. And so we were sort of forced to look for a good acquirer. And ING Direct was a fantastic deal. That was a big $7.5 million, or so they had 7.5 million bank accounts, online bank accounts. And we had 1.5 million brokerage accounts, and it was kind of a marriage made in heaven. And ING Direct was on a pretty stable foundation itself too, as a regulated bank. But it seemed like almost everything at ShareBuilder had been done just a little bit tighter. So I got off to a very good start, and then after ShareBuilder, when I was doing more and more work for different startups, I kind of found out that ShareBuilder was quite a bit of an exception. That other companies just had a lot of issues that I had to fix, or that I learned to prevent. So essentially, that's one of the things I've learned about startups is many of them have not been built on a solid foundation. They make a lot of unnecessary mistakes, and they pay kind of dearly for it. And in some cases, it sort of takes the company down. So that's how I got into it, and that's some of the stuff I learned from ShareBuilder.
Yeah. Well, all fascinating, and leads us to the book. Startup Law and Fundraising.
Yeah, you got your copy. I got my copy.
I have my copy as well.
It's a monster.
For those who are watching, I definitely recommend it. I haven't read the whole thing yet, but I've definitely been thumbing through it, and this definitely is going to be one of those books that founders need. So so I'm excited to talk more about this, and I'm assuming those unnecessary lessons or unnecessary issues that people have come up with is probably one of the reasons why you created the book.
Yeah, that's right. One day, literally, after I get a lot of calls, and I get a lot of calls from other attorneys who maybe have a little bit less experience, and they'll throw these crazy questions over the wall. And a lot of times they won't call unless it's pretty ugly, right? They're not going to, say, hey, I've got a situation I don't know the answer to. That's not anyone's favorite call. And so after just years and years of getting calls like that and seeing these similar situations with my company, it's like, oh, really, we did that with the intellectual property, or we did that with hiring people, or we did that in forming the company or not correctly forming the company. So literally one day, I think it was August 2nd, 2016, after some pretty ugly calls the day before, one guy had lost his company. I got a call from someone and said, hey, I was brainstorming in a bar, over a couple of sessions with some people, and talking about a business plan. It was really my idea, but other folks were kind of chiming in over beers. I formed the company. One of them wasn't involved at all, but then months later came in and said, hey, I'm really happy we got the company off the ground, that I'm a 1/3 owner. And this guy, literally had made this mistake that I talk about in the book. It's called essentially an accidental partnership. It's more formally called a general partnership. And to have avoided that, all he needed to do was sign some non-disclosure agreements in his personal name before he formed the company. And these NDAs could have said, this NDA is assignable to the entity that I will form, but it clarifies that this person, presenting the NDA owns the ideas that he's presenting, and he's not giving them away, and we're not forming an entity. And so absent that and any other formalities like forming a company first, which is a really good idea, this person had a colorable claim to 1/3 of the company. So I woke up the next day, August 2nd, 2016, and I thought, I've got an idea. I'm going to go around the country. I'm going to give a talk. I'm going to give this talk 25 times. And I set up a company that day, business law seminar group. And the other idea was that I wanted to travel tax deductibly around the country and see places, where I could climb mountains, ski at other ski areas, see friends in DC, see family in Portland. And I actually did that. I gave this talk 25 times in 15 cities. Bunch of the talks were in Seattle, but they were all over the place: DC, Boulder, Provo, Utah, Portland, Spokane, Boise. It was quite a bit of fun. And then after that, I kind of knew I had enough material for a book. And the mission really is and has been to help companies build on a solid foundation, avoid unnecessary and expensive legal and regulatory mistakes, and raise money successfully and legally to help the company achieve its mission. So that's what led to the book. And it was actually kind of hard to skinny it down to just the 580 pages. At one point, it was 900 pages. I knew that was not going to be, as popular. So it's dense with information.
Yeah, and before I go to my next question, there's a couple people that are asking. So Anthony just asked, where can you get the copy, and asked if Amazon, and yes, it is available on Amazon, correct?
Yes, it is. You can just type Startup Law and Fundraising, or you can type Paul Swegle. I think both will get you there.
Awesome.
Thank you, Anthony.
And a couple people said where they're from. We have people listening from LA, Seattle, Texas. Thank you all for listening and watching us here. Real quick, just to get a gauge of those listening, is anybody here a founder or want to be a founder? Let us know in the comments if you're a founder or wanting to be a founder, and kind of why you're here. And then also, again, feel free to ask any questions, and we'll do our best to answer as we go along.
Yeah, absolutely. We'd love to get some questions.
Yeah, Paul, I want to dig deeper on that first, like the impetus, where you're talking about that situation where the people were together, like having beers or whatever, and talking about an idea, and this person lays claim. So, to get in a kind of like a nuanced position on this, if the person would have formed a company beforehand and then discussed it with the person, regardless of the NDA, would there still be a claim to the company? Or is it because they had been discussing particulars of the company regardless of when the company was formed?
Well, so there's a few different issues to understand. The vacuum that is created by not having an entity is certainly the core problem in that situation, because you really can't have an accidental partnership if you're at a beer hall telling a friend about your new company. And they can't really claim ownership to something you've already formed. You've got the stock certificates that have been issued. They have nothing. But that's not to say that always using NDAs, isn't concerning. You should just always use NDAs, because people otherwise can steal ideas. They can steal information. And so you just really don't want to ever raise that specter of, giving someone the right to, or even if it's not a protectable idea, you're giving someone the idea and they can jump to market first, So I think, and it's awkward to present NDAs. And so one way you can avoid presenting NDAs is just not share any big secrets, right? So you can be very guarded about what you share. You don't have to say what your app is going to include and all the features. You don't have to whiteboard it at the bar. You can say, oh, it's an app for motorcyclists so that they can meet each other when they're out on the road, and it sends a signal. Hey, was that your Harley that went by? I'm Jeff. Let's get a beer. That was one of my law school exams. I'm also an adjunct professor teaching this stuff. And
someone's going to take that idea.
Yeah, I do, because on my motorcycle, sometimes I, see a group of fellows go by on their bikes. It looks like they're going somewhere fun. I'd like to be invited.
Nice. So going into, there's actually one thing I took a note here on the book that I wanted to ask you actually right up as the first one, and that is kind of like the loose end thing. So, I've been guilty of it myself in companies I've started where, we're just going fast and trying to do the best we can and then cleaning up afterwards. And sure, like hindsight is of course 2020, where we would have formulated all these things ahead of time. But in the case that we didn't do things the right way at first, what's the first thing that we should do to get, documentation or paperwork or whatever cleaned up? What's like the very first thing that founder or that company should do?
So I always like to think of it as a foundation of a building. And the stuff that is more toward the foundation, protecting core innovations, establishing an entity, issuing ownership rights in the entity early in a very sort of precise, proper way, protecting trademarks, establishing a trademark that you can build equity in. Those are kind of some of the core foundational things. And even before that, one of the things I talked about in my talk is under the foundation. In my talk, I talk about Roman highways. They last for 2,000 years. It's not just the highway, it's what's under the highway. And one of the things that's under the highway for under the structure for startups is the relationship of the founders. Founder incompatibility, founder disputes are the undoing of about 13% of startups that fail. And so, there's not really a loose end, but it is a very foundational issue that founders need to be on the same page about, the direction of the company, the end goal. Are we selling it? Are we taking VC money, or are we bootstrapping? Is this a lifestyle type of company where we don't need to take a lot of third-party money and we'll probably just keep it forever? Or are we on a fast track? We're going to take third-party money. We're going to realize that's going to cause founder dilution. But in the end, we're building a much bigger pie for an exit, either an IPO or a sale. So that founder compatibility is very fundamental. And I talk about it very right up front in all my talks. But other loose ends, really common loose ends are just not finishing the creation of the entity. And so I have a slide in my talk, and it's a supernova, a big bang. It's a big bang. It's like the creation of an entity should happen quickly. It shouldn't be something that happens in dribs and drabs. That is very dangerous. So sometimes a company, someone will file articles of incorporation, and then they'll just say there's a board, and they'll just say there's founders, and they'll just say there's founder stock. And somewhere all of those things don't get done. And so if you have a company that doesn't really establish a board and doesn't really issue founder stock, what do you have? Who's voting to make decisions? Then you go and you issue stock to others. Now, I don't think it usually gets quite that far, but in one of my recent exam questions that I wrote, it did get that far. And essentially, there were so many defects in the formation of the company when everything could have been done in the first week. There's so many defects that a lot of the subsequent financings and everything were essentially sort of unauthorized acts, ultra-virus acts, because there really was no platform for doing those things. Another key area that I always think is very important is issuing stock options timely. So, not every startup is a corporation, and not every startup is a corporation that's going to issue stock options, but about 95% of them probably are and do. Some startups are LLCs, and we could talk about that, but most high growth startups need to be corporations, because only VCs can only invest in corporations essentially. unless you have a very complex structure that I don't want to go into. So those are kind of some of the loose ends early on that are hard to fix if you wait too long. If you wait too long to issue stock options, for example, and you've promised them, then you issue them 10 months later. Well, you've caused a bit of a issue potentially for the optionees because they have much higher exercise prices. And so, those are the kinds of loose ends that are a little harder to clean up. It's not as if you have a bunch of board meetings and you don't get the minutes done right away, that's a little easier to paper over. If you do properly issue stock options and you're a little bit slow on documenting the paperwork and getting the signatures from the optionees, that's a more fixable problem. There's some things that I consider sort of more fixable, and then there's some things that really more, you can fix them, but they might raise issues later in a financing. If you've caused someone so their option grants are much less valuable, they theoretically could sue you at some point or turn on you because of the issues you've created by not doing the paperwork timely. So those are some of the loose ends that are very common.
And so what are some of the ways that founders clean up those loose ends? Is like, do I need to get a lawyer involved to do so, or just someone that's very operational to make sure that they are, someone on the team that's very operational focused to, check everything off the boxes? What are some things that a founder might do or a company might do in that scenario?
Well, I do think it's hard for any founder to create a company without the help of counsel. I just think it's not one of those DIY projects that's going to go well. The companies with the fewest problems, frankly, are the ones that are formed by, with the help of lawyers who really know what they're doing. You're aware that Pioneer Square Labs, for example, they work with big law firms. I think Wilson's and Cheney. Every company that goes through one of those more established labs has no rot in the foundation. Everything is done correctly. And so when they go to their first, second, third financing, when they're ready to do an M&A deal, it's just going to slip right through due diligence without any issues. If you get off to a little bit of a rockier start and there's some DIY, or maybe you didn't want to pay as much legal and you paid a little bit, so the entity was formed correctly, but you didn't consult on everything. I try and think in terms of what I call a likelihood and materiality matrix to prioritize cleanup. How likely is something to be a problem or to come to light? And then if it does come to light or become a problem, how significant, how material is it going to be? And I kind of think of, the upper right-hand corner quadrant is the most severe. It's most likely to happen and it's most likely to be severe. And then in the lower left-hand corner, it's less likely to happen and it's less likely to be severe. So sort of plotting these things on a matrix mentally, at least, and just sort of thinking them through. Another couple of ways to prioritize cleanup is to get your hands on a due diligence list and maybe simultaneously try and set up a virtual data room based off of that due diligence list. This is something that I do with all of my companies. First, I do a thing I call my general counsel audit, and I sort of identify the cleanup across 6 areas, and that's chapter 3 of my book. And then throughout the book, I talk about, and early on, I talk about due diligence lists, where to get them, what they're all about. It's essentially when you're doing a major financing and a VC is involved, their counsel is going to give you a list, and it might have somewhere between 300 and 750 or more questions and requests for documents. Show us your bylaws, show us your articles, where are all your minutes, show us all your contracts, show us all your trademarks, your patents, your copyrights, your leases. And so in the book, I have a template of a data room, a virtual data room, and it shows you essentially a puzzle. It's almost like a puzzle, and it has all this file structure, and it sort of guides you to identifying gaps. If you're trying to finish this puzzle by filling out all these folders in a data room based on what a checklist, a due diligence checklist is saying you need to have, then it helps you guide you toward a gap analysis. If it's being requested on a due diligence list, it's clearly material. And if you don't have the requested documents, if you're in a facility but you don't have the lease for some reason, well, you need to find a copy of the lease and stick it in the data room. So a gap analysis driven by a setting up a virtual data room that is informed by a due diligence checklist is a pretty good way to identify the most important loose ends.
Yeah. Yeah. I mean, I feel like we need to have a conversation offline. My entity. No, that's great. This is great. I want to see if we have any questions here that are relevant to what we've been talking about. And, a little bit here, this question comes up often. And so someone has, what's your view on setting up an LLC versus a corporation? That's from Anthony in Austin.
Anthony, that is a great question. Some of the answers are boring, so I'm not going to get too far in the boring stuff. Anything tax just makes everyone's eyes kind of water. So an LLC is the correct entity for certain types of ventures. A very easy sort of type of venture that I can identify as one that is good for an LLC is where you just have one or two folks and they're building a really cool company, but it might be what I consider a lifestyle company, meaning it's probably going to produce revenue. It might not need a lot of outside funding. And the goal of it isn't to take it public, and it isn't to flip it for, hundreds of millions of dollars. It's to build a company that throws off enough income to provide the type of lifestyle you would like to have. So it's called a lifestyle company. I say it sometimes in my talks, and people are offended, like it's some sort of derogatory term. It's a very common term. I didn't make it up. I'm not just, disparaging companies. It's a term. It's very common. You think of a small business. A lot of them are kind of lifestyle companies. It could be a restaurant chain. It could be a SaaS company. It could be anything, especially if it produces revenue quickly and you don't need third-party money. The benefits of an LLC are no double taxation, and also, if there's an asset sale, it's more tax efficient. So you'll always see that big property developments and oil drilling situations and shopping malls, they're all in LLCs for tax efficiency, because when those assets at any time get sold, if they're corporations, they're subject to double taxation. So LLCs are pass-through taxation. As the owners, if they put a bunch of money in up front, they can generally take those expenses and deduct them against other income. That's a huge tax advantage of an LLC. The problems with LLCs are that they essentially really don't work well for high growth, rapid growth startups. And there's a couple of big problems that I see right off the bat. And whenever I trot these out, people say, well, why don't I start it as one and then go to the other? We'll talk about that in a second. That is doable, but it's not my favorite approach. The benefits of a corporation are that more folks can invest in it. VCs cannot invest in LLCs because of an issue called unrelated business taxable income. VCs have limited partners who invest, and these are foundations and these are other sort of nonprofit sort of entities that have a certain tax status that prevents them from receiving income. They're not supposed to receive unrelated income. They can make investments, but it's essentially, I think you could view it as supposed to be very passive. In an LLC, they would get a K-1 saying you have this income, and they're not allowed to have unrelated business taxable income, UBTI it's called. So that means right there with an LLC, it's impossible for any VC to invest in them. Now, I said that in Utah, where they love their LLCs, and I love Utah, but they said, oh, we use blocker corporations, and the blocker corporations sit on top of the LLC, and then the VCs can invest in that. And I'm at this conference, I'm giving one of my talks, and I said, oh, what's it cost to set that up? I'm like, oh, not more than $25,000 or $30,000. And I laughed. And I said, well, I don't know about startups in Utah, but in Seattle, our startups hardly have a couple of nickels to rub together. So we're not spending $25,000 to form an LLC when we could just form a corporation. And so we had a good, we went around and around in Utah, but I think I won. So the thing about corporations that's important, there's a few of them Another one is LLCs don't issue stock options. And I hear this all the time. Companies, form an LLC, and I tell them, this and that reason to not do it. And then they, and I tell them, it's everything about it's different. And then they say, okay, we're ready to issue stock options. And I'm like, I told you, you can't issue stock options. It's a completely different way of compensating. There's really no comparable equity compensation vehicle like a stock option for an LLC. Now, I'll get people online disagreeing vehemently, and we'll go around and around, and ultimately I'll prevail, because what they will say is essentially, well, you can write up a bunch of documents and you can do it, and yeah, it's very expensive and blah, 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 and it's complicated and people don't understand it. And say, well, then why wouldn't we just do a corporation? Because everyone on earth knows what a stock option is. So that's another biggie. Then there's some more nuanced ones. One is called qualified small business stock, section 1202 of the tax code. If you get stock in a corporation and you hold it for 5 years, and that corporation was worth less than, I think, 50 million when you got the stock, that you will pay essentially no capital gains tax on the sale of that qualified small business stock if you hold it for 5 years, up to like $10 million. There's some thresholds, but it is quite a thing. And there is no corollary at all for LLCs. So that's a little bit my rant. I love LLCs for lifestyle companies because you get to take those tax deductions, and it's more tax efficient in some ways. But if you need to incentivize employees, very difficult. If you need to raise money from third parties, not impossible, but more complicated. And LLCs are a little bit more complicated because it's more of a contract. Corporations are more statutory and case law. LLCs were invented in Wyoming in the 70s. Corporations go back more than 100 years, and we have lots of rich case law. LLCs have very little case law, and virtually every complicated issue that I encounter with an LLC, it's an issue of first impression. So it's very tough to predict how a dispute involving LLC ownership or misbehavior is going to be treated by the courts compared to a corporation. That's my rant.
Yeah. Yeah. No, I mean, it's good to, even if it's something that gets talked about, it's definitely something that needs to get talked about, because, I know people that, quote unquote, know that they should do a corporation and they still do an LLC because it's cheaper on LegalZoom, right? Like you can do an LLC for a few $100 on LegalZoom.
I have no idea. I have never been on LegalZoom. I have,
but it's probably not in the long run. Yeah. Yeah, definitely.
And one thing that people hear is, oh, you can just convert. You can get those tax advantages for a couple of years and then convert. You can, and I did it not more than 12 months ago for a company, and I essentially worked with outside counsel at a law firm, very good law firm called Lee and Hayes, and I said, hey, I don't want to do this conversion. We're converting an LLC to a corporation, and we're simultaneously moving it from Washington to Delaware. We had to pay to draft 6 or 7 documents, and I've got a list of the process. I got a description of the process in the book, but it's not free, and it's not easy, and there's tax implications, and it probably requires getting a valuation for those tax implications. So people, especially people who are experts at tax, they kind of like to throw out that everything is easy. And I'm a little bit cynical, but I think it's easy because they're used to doing it, and they're not the ones paying to do it. They're the ones being paid to do it. Now, I love my tax lawyers. I love fellow legal professionals, but I don't think it's good advice to tell people it's easy to convert an LLC to a corporation. There's some paperwork, there's some legal bills, and there's always risk in forming any entity. There's always risk of an error. So if you have a conversion in mind from the beginning, you've essentially got 2 opportunities to create mistakes in establishing your governance foundation. So conversion is not, in my view, a preferred approach to building that into the creation of a company. I would rather pick the correct entity right up front and go with it.
Yeah. And so, with that, we have a question that's kind of similar online, and that is, what about fundraising for a co-op?
One thing that I talk
Sorry,
about.
that's from Finney in U District.
Finney in the U District?
Yeah, sorry, person's name is Finney, not like Finney Ridge. I was like in Seattle,
curious.
but yeah, Finney in the U District.
Hey, Finney, I have worked with co-ops. Co-ops are a thing. In my book, one thing I talk about is the idea of KISS, keep it simple, stupid. And I also talk a lot about doing things the way most people expect them to be done. When I was a younger person, my dad told me something about real estate. He said, don't buy the quirky thing that you want. Buy the thing that when you want to sell it, everyone else sees it as something that's normal, that has a great floor plan, that is not quirky like you would want, Paul, but what the rest of the market wants. And the rest of the market doesn't want a co-op. It's in general, right? You can't take a co-op. Well, no, I was gonna say you can't take a co-op public. I'm not positive about that. You could set up a structure and you can essentially do whatever you want if you have the money and the resources to design it. REI is a co-op. There's some other big co-ops, but raising money for anything that is unusual is probably going to be unusually difficult. So I don't even know what that would look like. When you're raising money, you always have to be able to tell people what they're going to get out of it. Is this a debt instrument, and you'll owe money and you'll pay on this debt a certain number of years later? Or is this equity that you're going to sell the co-op at some point? Do you sell a co-op? I think you sell interest in a co-op. I don't think you sell a co-op. So it's not something you could say you're going to flip. You're not going to take it public. Another investment vehicle that might work well for a co-op is called a revenue participation interest. And so maybe it could be structured a little bit like debt, that this person's going to invest $1 million and they will get 5% of the revenues for X number of years until the $1 million has been paid back 3X or $3 million. So that's one way of structuring an investment in a co-op, I suspect. But if you're going to do something different, you're going to have more challenges potentially funding it unless there's a very strong product angle, consumer product angle, or maybe a very strong social angle. And those things, a social angle, you don't even have to get investors. You can do Kickstarter and get money just because people are donating to a cause, and that could jumpstart a cooperative, for example.
Yeah, excellent. Paul, we're talking a lot about the founder side of things. I'm a big fan of like understanding what happens on the other side of the table, right? And so, yet we know, like you said, VCs would prefer a corporation versus LLC and so forth. And like the example you're talking about with co-ops, like, hey, like make it easy. Don't do something that's quirky. I actually like that example because I'm the same. I don't
want to dash anybody's dreams. You want to do a co-op, you do a co-op, but don't go to Madrona. Don't go to Madrona Investments or Pioneer Square Labs probably and say, hey, do you want to invest in my co-op? You're going to have to find other investors.
Yeah. And so when from the venture side, like how are they setting up their entities? Like if they're creating a company and spinning it out, or you sometimes hear these different VCs like, hey, like we're with you from the napkin, right? Like, or we're super early, and so which we all know is like very, very few and far between on scenarios there. But can you walk us on the other side of the table? Like if you were a lawyer on the VC side of things, either through diligence or setup or whatever, what are the things that you're looking for, and how are you looking at it from that side of the table?
Sure. And I've never actually been on that side of the table, but I've been across the table many times. So I hear your questions and I understand. And so one thing that I would suggest is, it's very easy to research questions that venture capitalists, VCs ask. VCs want everything very standardized. They want it to, they demand it to be a corporation. They almost invariably prefer it be a Delaware corporation. They want to, they're really buying into the founders, and they're really buying into, it has to be a very big opportunity for which they can receive. They're gunning for a 10x return. They're really not interested in companies that can't produce a 10x return in 7 to 10 years. And so if you're not in a space with an opportunity that big, and they also need to take an interest in each round of at least 20%. You know, the VCs need to have a significant enough ownership interest that if they're going to stay in for they're in the A round, they're going to stay in the B round, they're going to stay in the C round, they need to still have a significant interest through those additional rounds. So generally, they kind of want to take 20% of a company, and they also are looking. So they're looking at the team, they're looking at the size of the opportunity, and they're very focused on things called unit economics. And so they really want to understand the business model, and they're very focused on product market fit, which is, again, you have a huge opportunity that the market is clamoring for, that there's a huge product market fit, that folks really are going to jump on this product. And when it's sold, the company has good unit economics, meaning the cost, the profit for each unit that is sold. And it's defined differently for every type of business model. But if you're selling CBD drinks, it's the cost of selling that can of the CBD drink in the market, and your profit on that market, on that sale. Going back to the founders, they're very focused on this thing that I mentioned. Are the founders compatible? Do they have experience? The more experienced founders have, prior experience, the more likely VCs are going to be interested. So I think a lot of founders deal with this issue, and it's kind of a difficult one. If you've never fundraised before and returned a nice, done a great exit for VCs, you're kind of an unknown. And so that's just one of those things you have to get past. And obviously founders get past it, but you see that when serial entrepreneurs sell a company and then they want to form a new company, everyone's on them like ants at a picnic, right? So that's the ideal. And in the book, I kind of talk about the different things that you can position yourself on. Some things you can improve, some things you just have to talk away, deal with. But the other thing about the founders is their equity structure. VCs, I think, prefer that founders not just get their stock right up front. So if you approach a VC, you've been, launched this thing a year ago, it's going gangbusters, the founders own all their stock, they're going to want to try and impose a vesting or a reverse vesting on that stock. Essentially, you have to re-earn it. When Wilson Sonsini, I think, sets up for companies like Pioneer Square Labs, I think they do this. They do restricted stock, and they have it reverse vest. So it's subject to forfeiture, 100% if they leave in the first year, and then only 75% in the second year, and then 50% in the third year, and then, and so on. And so they've kind of got these handcuffs because the VCs are investing in the founders. And so they don't want to invest 10, 15 million in founders who own their equity. So if you're forming a company, you can anticipate that issue up front. And going with restricted stock that has a 4-year reverse vesting, essentially a forfeiture schedule, is actually very tax efficient, because if you do the stock at the very inception of the company when it's worth nothing, you can file a Form 83B with the IRS. You can pay all of the income tax for receiving that stock. So you can take it in as income, pay very little tax because it has very little value. And then you've also started that timeline, that 5-year holding period that I talked about under Section 1202 of the Internal Revenue Code, where if you hold that stock for 5 years, you also can escape a lot of capital gains tax. So that's something that VCs look at, is how how the founders have structured their equity. And I think that what I just described is probably what they prefer, but they would also be fine probably with stock options that vest over 4 years. The thing that's problematic is when a little bit and has to be dealt with is when founders buy their stock, they own it outright. I think sometimes VCs require that to be restructured, but I don't see all the deals, but I've heard that's the case.
And, we hear often in startup events and things like this about how you need to have a co-founder or how investors prefer co-founding teams, et cetera. Curious, just from a legal standpoint or from a structure standpoint, in a single founder scenario where single founder has the majority of the stock because they're the only founder and so forth, does that cause any not financial, but any legal issues? Or in your experience, how have you seen that take place?
Well, there's no hard and fast rules in life, so I don't want to sound like I'm rule bound, but I do think that VCs have a very strong preference for teams and not solo founders.
Sure.
And there is no legal issue there, other than the one legal issue: if the founder gets killed gets hit by a bus, the proverbial hit by a bus, what happens to the company, really? Right? When you have a team, you've at least got 2 points of failure. But VCs, I don't know what the percentage is that they invest in single founder companies, but I think it's very low. Yeah. And there's reasons for it.
Sure.
They want a team. They want folks with complementary skills. One's probably more the technologist, maybe one's more the product person, or one's really strong in finance, and one's in technology, a scientist and a finance background. There's kind of beauty in having a team that complements each other. And there's also this question of, if you can't find a co-founder, what does that, it's an unfair thing in many cases, not all. If you can't find a co-founder or someone who wants to form a business with you, maybe you're not that great of a team player. Maybe you have some narcissistic tendencies. Maybe you don't listen well. Those are the types of questions that I think VCs will ask themselves. Like, maybe it means you don't even have a network. Well, if you don't have a network, you're also going to struggle mightily to raise money. And so I think that's kind of, the bigger issue is, what are all the things that founders, what the VCs and other investors are going to ask about or wonder about. And you just, I hear this every now and then in meetings, like, well, you never know why someone doesn't invest. I've actually heard VCs say that. I've heard it twice. Well, that's kind of a gutsy thing to say. Like one time, and even just not even that long ago, someone was kind of bickering, back and forth about a deal term. And, my person was kind of sticking to their deal term, and I thought it was, probably not the thing they should stick on. And the person across the table with the checkbook said, well, you don't always know why someone doesn't invest. So the one founder thing is something they probably wouldn't say anything about. And I have seen solo founders just get crushed in front of VCs. And there's also this tag team that goes on in every VC meeting. So I always love when two founders are kind of, one's listening and the other person's, one's talking and one's maybe listening, and they kind of tag team, and they're both prepped up on all the answers, but they kind of relieve each other. And another thing that founders do is they kind of console each other in difficult times, right? And they act as a sounding board. So I do see a lot of practical value in the relationship. Being a team and supporting each other as a team that a solo founder just doesn't have. For sure.
So we have about 10 more minutes left. So if anybody watching has questions, please make sure that you ask them. I want to ask Julia's question real quick, and that's just simple. Do you have a legal counsel for startups that you recommend? Do you yourself still do legal counsel for startups, Paul?
Yeah, I do. And with the pandemic, I lost one of my companies to the pandemic. And then during the pandemic, in a deal that had been well in the works, Abbott Laboratories bought another one of my companies. So, I currently have some bandwidth. I have two ways that I structure my legal representation of startups. I'm of counsel at a law firm where I structure hourly billing models. And then also I act as part-time in-house general counsel. So I'm essentially a member of the team, contributing a certain amount of my time for a certain salary and maybe some options. So I'd be happy to talk. And what was her name, Jenny?
Julia.
I'm happy to talk with anyone out there, and I make a lot of referrals too. And I do have, certain go-to people that I refer a fair amount of business to, just because when I refer them, people say, "Hey, that was a great referral. I'm getting along great. They're giving us great service." I tend to kind of do repeat referrals. So, you can reach out to me, Julia, at my email address, which is pswegle@gmail.com. So that's pswegle@gmail.com. And I'm also just happy to talk about your situation and see if someone else would be a better fit. I do know lots of lawyers. I'm on just finishing up a 3-year term on the Board of Governors of the Washington State Bar Association. So if anyone knows lawyers, it's probably me.
That's awesome. So Paul, with all the things that you've been doing throughout these years in this book, you also teach at the university, is that correct?
Yeah, I'm an adjunct professor at Seattle U, and I'm essentially teaching this course, but I renamed it so they couldn't take my trademark, Startup Law and Fundraising. There I call it Counseling Startups, Law, Regulation, and Fundraising. And I do it in the summer in June, and it seems like it's a big hit, and I might start offering it at other law schools virtually.
I was gonna say, do you have to be in law school to take it? Is it something that people who are not in the legal profession could take as just additional education?
No, you do have to be at an accredited law school. So, and again, I went around the country and gave this talk that I loved giving, and I might start doing that again. I haven't even really thought too hard about it, because we can't. I was doing them at Galvanize and at Surf and at other workspaces, 1776. I did Galvanize in Boulder, 1776 in DC. So with the closure, and I think Surf Incubator, I think it has gone under. And I hope that we don't lose too many other of our precious incubators. I think, the Riveter, I think, has gone under, hopefully not permanently. And so I kind of liked doing those in person and just really kind of getting to know people, but I might do them virtually. So I have a meetup group, Startup Law and Fundraising meetup group on Meetup, and I just sort of kind of reactivated that the other day. And so there might be more even informal opportunities, either online or once things open up, to get back out and do some of these fun meetups where we just sit around and drink beer and talk about, I just field startup questions and hear what people are up to. So go to my meetup group, Startup Law and Fundraising, and register there, and you'll be aware of any meetups and any startup seminars.
Excellent. Paul, so you've done a lot of stuff with startups, and so you're obviously entrepreneurial with these books and those sort of things. Like, are you ever going to do your own startup? Have you done it? You're your own startup?
Well,
I know this obviously, but have you ever done a tech startup or anything like that?
No, I have some serial entrepreneurs that come to me, and we've kind of done a couple of them together. And so I kind of like to be on a team, and I almost sort of like to be, everyone should want to be on a team with people who are better than them, right? That's take that one with you. You should always be on teams with people. You should be the worst person on the team. I'm always the worst person on the team. And so I have some go-to entrepreneurs, that call me up on a somewhat regular basis, say, "Hey, would you do this thing?" And I reject some of them, but hey, you keep trying. And so I don't really need to do one from the ground up. I have my publishing company, and I'm going to do a third book called Careers in the Law. So I'll have 3 books, just kind of throwing off cash. That's a lifestyle business. That's a single member LLC, and I also have one of the highest rated Airbnbs in the state, which is weird.
Oh, nice.
I think it's in the top 10 highest rated Airbnbs in the state. So I got almost too many things going on. I'd like to do more professoring just for kicks, because that is a lot of fun, and I like working with students. So.
Yeah. Well, let me just look at these last few questions before we wrap up here. This is a question that some people probably have as well. Anthony again asks, if he's going to start investing in startups, should he create a single investment company that he capitalizes, or should he set up an entity for each investment?
That is so interesting.
Like, because I know some angels do that, right? Well, they'll have like an LLC for each investment they make.
Yes, and frankly, I mean, I've done that too. And I guess, again, one thing I say is I'm not a tax lawyer. So like, there's very few areas I just wash my hands of. There must be tax advantages, right, to investing through an LLC. I don't see that there's any legal protection. Normally you set up an entity for legal protection. There's maybe two reasons to set up an entity: legal protection or tax. And so it's been a while. I did have a lot of ShareBuilder stock, and at some point a tax attorney said, we're putting it in this LLC. And it's been so long, I don't even remember exactly the reason. Now VCs and angels set up entities so that they can set up a structure, and I kind of understand those structures. One person is kind of the syndicator, the key person, and they get carry, so they get extra, payout at the end, and then they bring in limiteds, and so everyone is investing in one entity through in a company through one entity, right? And so that's a very different reason. Pooling investments is another reason for using an entity to invest. I guess, I just really had never thought about it. I've done a certain amount of investing, and I've always just mainly invested in my own name. But there's probably a better answer than that I don't have.
All good. And I guess the last question before we wrap is, do you do any work with international startups or startups that deal with international business?
No, I refer those to other people. I guess in addition to tax, international. I've had to do a lot of international. One of my companies managed data in 47 countries.
Wow.
And so we had 47 roughly law firms. We're getting paid well enough to do it, but it's not the most fun thing to manage, because as a lawyer, you don't know the laws of another country. I mean, you really don't know all the laws of another state, but another country is a completely different beast. And you really have to have close relationships with international law firms that kind of tie it all together for you. And that's just kind of a bigger law firm thing. I would go to a bigger law firm for that kind of advice. Although one thing I might do with the book, so I said I set up the company because I like tax deductible travel. I may start talking more internationally now that this second book is out. My first book, I don't even think I told you, is Contract Drafting and Negotiation. And that one is very practical, also much smaller. It's only 154 pages. But with both books out now, I probably could go traveling, through Europe and so forth, and learn more about international, startups. I think we have the best laws for startups. And so going international, unless that's where your market is, doesn't make sense necessarily to me. I think the U.S. is a very solid jurisdiction for startups based on some of the things that we talked about.
Got it. Paul, question I like to ask everybody is, what is a question that you have that you want to ask our audience that they can think about as they go about their day, their evening? What's a good question you want to leave them with?
And this one goes out to the founders. So you don't ever know exactly when an M&A deal, a big offer to buy your company is coming along. You don't ever know exactly when a big venture capital firm like Madrone is going to step up and say, hey, we want to give you $8 million. And that due diligence list is coming. What are the 5 things that are going to keep you up that you have as loose ends that you need to fix before you're going to get through due diligence? what are those things you need to start working on now so you don't lose a financing or a deal?
Yeah. Yeah. I'm like scared just thinking about that. So that's a great question. Paul, what are some good ways that people can get in touch with you? You mentioned that a moment ago, but what are the best ways for people to either pay attention to what you're up to or get in touch with you?
Sure. I'm on Twitter, and I think it's just P Swegle. And almost daily, I kind of point out things that I think are of interest to founders and startups. I post somewhat regularly on LinkedIn, and those tend to be deeper things. I have a blog, Startup GC. So if you type in Startup GC, you're going to go to my blog, and you can sign up there. I'm going to be posting. I posted something I thought was really helpful about the top 10 sort of common equity compensation mistakes. And then the next day or two, I'm going to post about the work of Startup GC and how that is a way that startups can close the gap between, a big law firm and no legal at all. And it's also kind of meant to help other lawyers look at sort of that career that I have where I'm in-house part-time GC to a bunch of companies. So Startup GC, and then also it's startupgc.us, I think. And again, my email address is pswegle, pswegle@gmail.com. And I'm happy to field questions and maybe make referrals to other attorneys for almost any kind of legal question under the sun.
Excellent. Paul, it's been great catching up with you. Thanks so much for joining us this evening.
Thank you very much for inviting me, Jonathan. It was a lot of fun.
Everybody, thank you for listening to this special live episode of the TF podcast. Please do us a favor and make sure that you're liked and subscribed on our YouTube as well as our podcast channels so you can listen to this as well as our other shows. You can follow me at JG Products on Twitter, as well as TF Labs at TFLabs_, or you can learn more about what we're up to at tflabs.io. Thanks so much, and we'll see you all soon.